Great afternoon, everyone, and welcome to this week's Lunch and Learn series with Otrain. We're very excited to have Mandy Can from Can Consulting join us today. But first of all, a little bit of housekeeping. If you're watching via our web page, which is a Lunch and Learn series with Otrain, if you could let us know who's here and get used to asking questions through the chat box. It's just in the bottom right-hand corner. Feel free to put your name in there and we'll give you a shout out later on. Now, today's topic with Mandy is how to avoid the top 5 HR blunders. So let's face it, no one wants a call from the Fair Work Ombudsman. So setting up your HR practices correctly from the beginning is really, really important. What's even more important is to consistently review your HR practices because, as Mandy will tell you, there are always changes to make. So get up to speed with this Lunch and Learn series with Otrain, and I'm going to hand you over to Shane now to talk about why he's really excited about having Mandy speak about something that he's really passionate about and why he wanted Mandy to speak to you guys. So great afternoon, Shane. How are you?
Hi, Emma. I'm great, except my speaker just died, would you believe? So I missed I got none of your intro, but that's okay. I got the hand over to me, which will be fine. So I'm really excited to have Mandy here today. Thanks, Mandy, for agreeing to participate. I guess I just want to go back a step and talk about the lunch and learns. And I've had a few people say to me over the last couple of weeks as we've held these, why are we holding these lunch and learns? You know, our business puts training online, and suddenly we've got someone like Mandy coming in to talk about industrial relations today, and the two don't make sense necessarily. And I guess they make sense for me because our lunch and learns are about increasing capacity and building productivity within the workforce, which is what I think Otrain does. It's not just about putting training online, it's about increasing productivity. And part of that productivity is about all of us getting better at all the things that make up our role. And given that most of the people that we talk to and most of the people that join us on these lunch and learns are in a management role or a HR or a training role, things like industrial relations are really key. So I'm really excited that we do the Lunch and Learns, of course, and I'm really excited that Mandy can come and not talk about training, but another aspect of building capacity and building productivity, within the workforce. And I'm really, really excited about this topic, which kind of makes me a little bit crazy. I've been involved in employing staff in my own business since 1999, and through that time I've seen the old Industrial Relations Act. I don't even know what it's called now. Maybe Mandy can refresh us. The introduction of work choices in 2006, and then the Fair Work Act in 2009. And what's interesting in my own business is that we spent thousands and thousands of dollars trying to find out what the introduction of work choices, first of all, and Fair Work, second of all, what their impact would have on our business, what we needed to do differently, and what we needed to be doing to make sure we were complying with the new legislation. And interestingly, we spent all that money and got very little advice. And the reason we got very little advice was because the legislation was so new that there was no precedent, there was no case study. Everybody was looking at the legislation, almost trying to guess what it meant and what would be required. Well, the Fair Work Act came into play in the 1st of July 2009, so we've had nearly 4 years of experience where employers have done things and employees have brought claims, and now there's actually some precedent, some case studies. So I'm really excited to hear and learn about what's played out and what's come about in terms of the courts and the case study, in terms of how we should be doing things with this now not so new legislation. So Emma, that's I know I'm geeky, I know I'm nerdy, but I love that stuff. So thanks, Mandy. Thanks for joining us, and looking forward to this. Looking forward to the show.
Oh, thank you, Shane.
So thank you so much, as Shane has said, thanks so much for joining us today, Mandy. I'd like to introduce Mandy Can, the Director of Can Consulting, who will be sharing with us, as we've introduced, the top 5 tips for getting out of HR blunders. So welcome, Mandy. Would you mind sharing with us a little bit more about who you are and what you do?
Thank you, Emma. And like Shane, I'm a bit geeky when it comes to the industrial laws as well. I love this stuff. I work mainly in the IR field. The other part of my business is HR consulting. So I do most of the IR work, being the Fair Work Act, National Employment Standards, awards, agreements, contracts and things like that. And my colleague does the HR side, recruitment and selection, employee handbooks, development, things like that. So I'm very excited to talk about the Fair Work arrangements today, and certainly, we can't go too much into the history of, what was before in '96 around work choices and what is now the Fair Work Act and the National Employment Standards. So I have the 5 tips for the listeners today, and I'm certainly happy to answer any questions after the session.
Excellent. Well, thank you so much, Mandy. I'm sure Shane will have lots of questions as well. So let's get straight into it. And your number one HR tip is pay rates. So there's a lot of discussion around this and a lot of information around this. What's your thoughts around pay rates?
Okay, well, a lot of my clients and new clients phone and say, well, what do I pay this person? So I guess my response in that situation is we have modern awards, and they actually dictate what the base pay rates are, the overtime rates, the penalty rates and things like that. So that's the base of what you need to pay a person. But I suggest to my clients that they look at the market rates as well. So in particular, if you're recruiting for a role, if you need a new salesperson, for example, have a look at the market rates. What is the market paying for this person? Because if you go in too low and just pay the base rate, you won't have anyone applying for the position, or if they do apply, they're not going to get too far because you're not satisfying what one of the requirements are, and that's a reasonable pay rate. So look at the modern awards, and if you need some help with which modern award you're classified under, you can actually phone the Fair Work Ombudsman, or you can go onto their website, Fair Work Online. You can even check the award through the award finder, where you put in some key information around your industry, what state you're in, things like that, and all of the modern awards that they will come up in a search. So you just click the most relevant one. But a tip with modern awards is they're industry awards. So you need to understand that they are based on the industry, and you need to click into the right one and have a look at the coverage first of all to make sure that it covers your industry, and second of all, you need to have a look at the classification structures so you're classifying that person correctly, and that will then form your base rate of pay, and the award will outline penalty rates, overtime rates, things like that. So use the Fair Work Ombudsman's website as a good tool to firstly check your award and to check your rate, your base rate, because some people are still covered under the transitional arrangements, being the NAPSA awards. So that's where it gets a bit sticky, and you'll need to get some advice around those transitional arrangements because they apply to actual base rates.
So Mandy, how would you advise, so that's all to do with the pay rates and the award, how would you advise a client to research the market rates?
Yes.
Do they just go on to Seek, or how would you advise a client to do that?
Well, Seek does actually have market rates. So there's a bunch of reports out there, and you can actually purchase a report, or you can log on to Hays, Hays, and have a look at their salary guide. And you can click into your industry and have a look at their salary guide per industry. They'll actually just email you that part of the report. I've found that very helpful in when I'm researching market rates for my clients, to have a look at the Hays salary guide. But a whole bunch of recruitment agencies actually do a guide as well. So you can log on to a recruitment agency that you may use and get their guidance on the market rates, because as you can appreciate, they go up and down depending on, supply and demand, that type of thing.
Yes. Shane, do you have any thoughts on what Mandy's just said? You've just given us a whole bunch of resources, so thank you so much. Shane, with your experience of hiring and firing, on the hiring side of things, is that a process that you've been through with, researching the award rates and the market rates?
Yeah, and I guess a couple of things that we've found in our recruitment business. In terms of the market rate, one of the things that we do, and we have a standard interview question for every candidate, and that's, you know, how much are you worth, or how much are you looking for? And we don't make any promises, but we ask that question, and it's interesting, you know, to get a feel from the candidates that are in the pot. We never advertise pay rates when we advertise a role, so that's something that we do internally. And with the Fair Work site, Mandy, I'm interested, one of the things, or the challenges that we have all the time is, you know, the legislation is fairly ambiguous, and there's multiple ways that it can be interpreted, from you know, things like categories of employment. Even you mentioned that the NAPSA and the transitional arrangement, which was, you know, for those people that don't know, bringing all of the state awards in line under one federal award. There was different pay levels, and suddenly they had to make them the same. So it transitioned out over 5 years. But how do you either make sure you've got the right rate, or B, cover yourself, so if you have got the wrong rate, you can at least demonstrate that you've tried your best to you know, or interpreted the award in such a way that you know, that was the case?
Yep, sure. With the Fair Work Commission, they look at it over a test called the Better Off Overall test, or the BOOT. They need to ensure that people are better off overall. So in particular for professional roles, if you're saying, well, this is our salary range, we're going to attract people that want that type of salary, and I'd say some of my clients don't like to advertise the salary, particularly on Seek, but for the lower level admin, manufacturing type roles, I always suggest that they advertise the salary. You want the person to do a self-selection there. So if you're just paying just above the award rate or the award rate, always advertise the salary, because that will certainly weed out people who are applying, and you won't have to go through 300 applications. So for the professional roles, and having a figure in mind of what you deem to be reasonable, you just need to know what the base rate is, and then if they're going to do reasonable additional hours, i.e., you know, they might be required to do 45 hours a week, you need to make sure that they'd be better off overall from the base rate, overtime and penalties involved with that, a rate that is going to compensate them for those reasonable additional hours. And I get that it is quite difficult when you're coming to that realisation of, well, actually, what is the base rate? I might be under a NAPSA or I might not, but the Fair Work Ombudsman are there to answer your questions. So I'd say phone them, or try the award/pay checker plus and do that first. But if you're confused, phone them on their 1300 number. They are there to help people to do the right thing. And even if it comes to a dispute and you had all the best intentions, that is your defence. You're not underpaying them because you're a mean employer. You just didn't have all the information, and that's particularly pertinent for a small business. So that's under 15 head count, which is what the Fair Work deems a small business. They need to have a look at, you know, what's the undertaking of the business, what size are they, did they have dedicated HR, things like that. So they're quite forgiving if you're not intentionally doing the wrong thing, and they are there to help you.
So Mandy, once you've established the pay rate and you've got the right candidate, your next tip is about employment contracts. And I mean, we could probably do a whole separate session on that, but if I could get you to share with us your insights into the employment contract, that would be great.
Yep, great. All right. So with an employment contract, it can be written, it can be verbal, or it can be implied. So for example, a small family business that's employing husband, wife, daughters, uncles, things like that, family, friends, they often grow to be quite a sizable business. Now, in saying that, they may not have employment contracts in place. However, when you employ somebody, if you don't have it in place, it's an implied contract. So you should be paying them a reasonable rate. I always state to my clients it's best to have things written down, because if it ever goes to dispute, that's your evidence of the agreement. So with an employment contract, there needs to be an offer of employment. That offer then needs to be accepted. Each party has accepted an obligation to perform his or her part of the agreement. Both parties intend to create a legally enforceable bargain which will be binding. So each party has the capacity to enter into a contract, so people are of sound mind when they're signing these contracts, and they're written in plain English that people can actually read and interpret and understand. Both parties truly consent to the terms of the agreement, and the contract does not contradict a legal requirement. So, for example, they're paying an employee less than the minimum wage. You must comply at least with the modern award pay rates.
I see you. Sorry to interrupt, Mandy. I see you laughing there, Shane, about the written in plain English. Have you had different experience?
Yeah, you know, my lawyer would hate me for saying this, but some of the stuff that, you know, the legal talk lawyer contracts, and certainly our experience has been just something fairly simple, just 1 or 2 pages, you know, documenting a conversation, even in dot points, you know, rather than legal verbatim taking out a 36-page contract. And, you know, people are happy to sign it. They understand. It doesn't end up with weeks and weeks in more senior roles going between legal counsel and costing thousands. So I'm all for just a quick note and a couple of quick signatures, you know, dot points. And to Mandy's point, making sure that you're not trying to, you know, contract anybody out and of their entitlements, and it's all done in good faith.
Yes, yeah, very good point. And it doesn't need to be a 30-page document. For people who are generally covered by modern award, that sets out the terms and conditions of employment, and all they need on top of that as an offer is really a letter of offer stating, well, this is your start date, this is what we're paying you, confidentiality requirements, leave, things like that, all those key issues, and that can be done in a 2-page document with a position description attached to it. And essentially that's their contract of employment. So, but I would say for more professional services, so your best sales consultant, have a detailed employment contract. You'll need in there things like confidentiality, be quite specific there, and restraint of trade. You don't want that person going to work for your competitor within a very short amount of time or taking your client list. So you need to be careful there and have a really well drafted employment contract. And just on that point, and Shane, you'll probably agree, is that you don't need to go to a lawyer for an employment contract. You can come to an IR expert. I've done many and varied employment contracts from direct employees, independent contractors, people like that. So I can certainly help people draft up an effective employment contract.
Excellent.
And I guess, yeah, my comment there is the most important thing is having one, regardless of who drafts it. You know, the number of times we've ended up, you know, working with clients, you know, where everything starts out well, runs for 18 months or 2 years, and then for whatever reason the relationship breaks down. You know, anything documented, even some scribble on a napkin from a lunch would have helped. You know, things like overtime or flat rates. So, yeah, absolutely agree.
Yes, yeah, and it comes down to the evidence. If they do lodge a dispute, you will need to trot out your evidence, and they will obviously have theirs. So with a detailed employment contract, which you can always vary down the track, you know, that's your coverage for your side of the agreement.
So Mandy, once you've had the employee for a while, and this is something that I notice with some of our newer clients, is they may have not have done a performance appraisal for 2.5 years. How important are performance appraisals to your HR strategy?
Very important, I believe, because if it comes to an underperformance issue, you know, there's not a lot that you can do if you don't have the evidence for an unfair dismissal claim. So I always take the approach with my clients is that all employees should be periodically appraised on their performance, and you need to be prepared and go into a meeting, a structured meeting, and you need to give them both the positive and the negative aspects here. So in terms of the negative, it's always that constructive feedback on where they're underperforming, and the positive is you're really performing well in these areas, but we need you to perform better in these other areas. So my first point there is to be prepared. Make sure that you know, you've got all the information. You've got past performance appraisals, you've got training records, you've got, you know, error rates, customer feedback, things like that. So you can really discuss what it is in the performance appraisal, and never ambush the employee. So always give them notice of the meeting. So we're going to talk about your performance. You know, come along to the meeting and we'll have a good chat then. Don't just focus on the negatives. So just because they're not meeting sales targets, you know, they might be working well in other areas. So always give them that balanced perspective. Document it. That is very important, particularly if they can't improve their performance and it leads to a termination process. So you need to have your documentation there, but just before that, give them an opportunity to respond to your feedback. In particular, if it's negative, you talk very frankly about what it is, and you give them the performance target. So say what you need it to be, but then you get their side of the story. So what's been happening? Why are you underperforming in this area? And that's particularly important if it leads to underperformance. It's the procedural fairness side of things that you need to make sure it happens.
So that's one strategy to help with managing poor performance, but you know, obviously that's also in place to support people that are performing, to give them feedback. What are some of your other strategies you can share with our viewers as to how to manage poor performance?
Okay, so when you're going into an underperformance meeting, that's totally different from a performance appraisal. So, you know, I see this a lot. People or managers or even employers, they're often very reluctant to address poor performance issues until it gets to be a huge issue, and then they want to fire the person on the spot. So when they phone me and they talk about, I'm wanting to terminate this person, I really have to backtrack from there to ensure that they have managed it effectively, and if they haven't, we'll talk about their risk involved in terminating a person's employment, because that is very serious stuff. So I guess you need to identify the problem and be very specific about what it is. So, for example, if a salesperson or a sales consultant isn't achieving their key performance indicators, they may be achieving some, but then others they're not. So you need to talk about that and be very specific about what those KPIs are and how they can perform better, and give them a reasonable time frame to improve their performance. That is to ensure that you're complying with the procedural fairness arrangements. So, you know, tell them how serious the problem is. So if they're not meeting really important KPIs, you know, it could lead to termination. So you need to advise them if they don't improve their performance within the required time frame, you may consider termination of employment. So be really clear there and talk about the gap, the performance gap, and how they are going to actually plug that gap. So in terms of what they need to do in what time frame to actually meet their performance standards, and then once they're up to standard, you'll then talk about how they can be very effective in their performance. If this meeting is the second or third meeting and you're talking about the same thing, you would reasonably consider termination. So at that meeting, you need to offer that person a support person. Now, in saying that, a support person can be a union official, a union delegate, they could be the wife, the partner, they could be anyone, but they can't be a legal person acting in a legal capacity. A support person is there to support the employee in discussions that are quite serious around their performance. They can't speak on behalf of the employee. So if people need some information about a support person, I've heard some horror stories about them taking over the meeting. that's not appropriate. You need to interact with your staff member and you need to tell them what the issue is, how serious it is, and how they can improve, and give them an opportunity to respond to the issues.
Excellent.
So, sorry?
Mandy, we've just had a couple of questions come through, and I'm just mindful we've only got 5 minutes left. So you covered the 5 top things, so I just want to cover those off again. So we've discussed pay rates and having the checking that you're at least reaching the award, but also researching market rates. We've gone over employment contracts. You had great content in there about that. Performance appraisals, which really led into as well managing poor performance, which, as you clearly defined, that's a totally separate thing, which is fantastic. And then managing poor performance into, hopefully not, but into terminations as well. So a couple of the questions that have come through, Mandy, is, which I think you already addressed, can post-employment conditions be put into employment contracts? For example, future employer restrictions.
In an employment contract, what survives the termination of the contract is the restraint of trade and confidentiality clauses, generally. Yes. So they survive the ending of that employment contract. So restraint clauses are generally from 6 months to 2 years, depending on what the role is. And of course, any confidential information that they have or is in their possession, you need to specifically ask for that to be returned. But you know, if there's copies and things like that, the confidentiality clause does survive the termination of the contract. They can't use that material because it's the employer's IP and things like that.
Excellent. Now the second question is, what about paying employees a flat rate regardless of number of hours worked or times worked? Is it okay as long as the rate paid satisfies the boot when compared to the modern award rate?
Yes, and the risk there is that the employee may go a back pay claim with the Fair Work Ombudsman, and what the employer needs to do is justify that this flat rate did satisfy for the hours, the penalty rates, overtime, things like that. So as long as the employee would be deemed better off overall, that would certainly be okay, and you would need to argue that case if it went to dispute. So you can do it, but you just need to be careful that they're better off overall.
Okay, excellent. Now, did you have any other final points that you wanted to deliver today, Mandy, or you've covered so much? Thank you.
My pleasure. I guess the last point is termination. So if the underperformance or any sort of serious misconduct leads to termination, it's always best to get professional advice. So I provide an on-call HR manager service. You can use it once, you can use it 100 times, but it's always best to get advice from an IR practitioner or a very dedicated HR practitioner before you terminate somebody, because they can go unfair dismissal, which is lodging an unfair dismissal claim with the Fair Work Commission, and then the onus of proof is onto the employer to prove that they terminated that person fairly. So again, you need the evidence to say that you've satisfied the procedural fairness requirements, you haven't unlawfully or unfairly terminated that person, and it's never nice to get up in front of the Commission and justify why you terminated somebody, because it's often the last resort for most employers. So always get the advice pre-termination. I would never advise a client whether to terminate or not terminate. I give them a risk factor in terms of the evidence put before me, and if it did go unfair dismissal, what their likely result would be in the Fair Work Commission.
I bet you have seen some amazing things, Mandy.
I have, and again, Shane, I'm very excited by the industrial relations arena. That's my passion, and that's where I love to work. But yeah, I do have a laugh to myself at times, and then I do worry for people who are trying to do the right thing, because ignorance is no defence under the current industrial relations regime. They are a bit more lenient towards small employers, but if you just terminate somebody because you don't like them, expect an unfair dismissal claim.
Well, thank you so much for joining us today, Mandy. If anyone wants more information from Mandy, her website is canconsulting.com.au. I got that right, didn't I, Mandy?
Yes, you did.
Excellent. So yeah, so I'd advise everyone to go over there. We've also put a link in this event to your frequently asked questions page, which has a phenomenal amount of information on there. So go and check that out. So thank you, Shane, for hosting this with Otrain today and presenting this with Otrain. Any last words from you?
No, look, I just want to reiterate the importance of documenting. Mandy, thanks very much. I wasn't aware of the implied contract scenario, but I have had personal experience of paying someone a flat rate only to end up in a dispute sometime later, and the flat rate being used as the base rate because I didn't have it contracted. So we loaded up the payment in the beginning, and then had to pay penalty based on that. Didn't document it. So reiterate, document, however formal or informal it might be, because gentlemen die and gentlemen forget, and when relationships break down, it's amazing how circumstances appear differently on both sides of the fence.
Yep, good point.
Excellent.
Well,
thanks, Emma. Thanks for a great session.
That wraps us up for this Lunch and Learn. We've already started receiving registrations for our next Lunch and Learn in 2 weeks' time, same place. We've got John Bellamy, who will be talking to us about how to get the most out of your time's investment in LinkedIn. So LinkedIn's a very hot topic at the moment. For those of us in B2B, it's a must-do. So I'm looking forward to sharing more information with Lunch and Learn with Otrain then. Thanks, everyone. Have a great 2 weeks.